Yes, ma'am.
This Honorable Court of Appeals is now in session.
Good morning to the attorneys. Welcome to the Tennessee Court of Appeals. Your panel this morning consists of Judge Bryson, Judge Davis, and myself, Judge McClarty. We will proceed on this case as if you were actually in court. I normally say you don't necessarily have to rise during your presentation, but I see one of the attorneys is already in a standing position, so that would be no problem with that, however you make your presentation. If there is any technical matters that develop during the course of your presentation, please let us know immediately so we can get to the root of the problem and get it resolved. If there's nothing further we need to consider, Madam Clerk, will you call this case for hearing?
Bearing Distributors, Inc. versus David Gerregano, Commissioner of Revenue, State of Tennessee.
Thank you. For the appellant, are you prepared?
Yes, Your Honor. And just so the court is aware, of reserving 3 minutes for rebuttal.
Yes, sir. You may proceed.
Thank you. Good morning, Your Honors. I'm Chris Wilson, and I represent the appellant, who I'll refer to as BDI. The issue in this case is whether BDI qualifies as a wholesaler or as a retailer for Tennessee business tax purposes. And just as background, the Tennessee business tax imposes different rates of taxation on a variety of different classifications. One classification distinction it being whether or not a taxpayer is a retailer or a wholesaler, which that distinction will affect which particular rate would apply. Under TCA 674-702, a wholesaler is defined as a taxpayer for whom more than 50% of taxable sales constitute wholesale sales. And a wholesale sale is defined under the same statute as including the sale of industrial materials for future processing, manufacture, or conversion into articles of tangible personal property for resale where the industrial materials become a component part of the finished product. In this case, BDI sells mostly to manufacturers that either one, incorporate the product as a component part of a manufactured good, these sales being undisputedly wholesale in this case. Two, they may incorporate BDI's products into manufacturing machinery used in the manufacturing process, which BDI asserts qualifies as wholesale, but the department asserts is retail. Or three, customers may use purchased goods for a variety of both of the aforementioned purposes. We'll call those mixed sales. There's no dispute in this case that 674-702, the provisions thereunder defining wholesaler and wholesale sale, constitutes a taxing statute, which must be liberally construed in BDI's favor and strictly construed against the department. Applying this standard and the proper statutory construction standards set forth in our brief to BDI sales constitute wholesale sales, regardless of whether the items are incorporated into manufacturing machinery or become a component part of a manufactured product. The department in this case cites to various tax exemption cases to argue that industrial materials must be incorporated into a final product across the board in order to qualify as a wholesale sale. However, in tax exemption cases, exemptions are to be strictly construed against the taxpayer. And this is a very different construction standard from what we have here, which is the standard of a taxing statute, which is to be liberally construed in favor of the taxpayer and against the department. And in fact, in our briefing, we cite to the Phillips v. Buttorf case, wherein the Tennessee Supreme Court recognized that applying one of these standards over the other generated different outcomes in a case involving the construction and application of a sales and use tax statute and regulation, which contained language similar to that at issue here. While the Buttorf case admittedly did not involve the same statute or the same exact legal arguments that are presented in this case, the Buttorf case does illustrate the crucial difference that an application of a construction standard has when construing a taxing statute or a statute of taxation, since like what we are dealing with here. In this case, if the court finds that goods sold to manufacturers must be physically incorporated as a component part of a manufactured product in order to qualify as resale, or I'm sorry, as wholesale, as advocated by the department in this case and held by the lower court, then Tennessee's business tax regime imposes an unconstitutionally impossible burden upon BDI to determine customer use of each product they sell. As noted earlier, in order to constitute a wholesaler, the statute expressly requires that more than 50% of taxable sales must be wholesale. This language on its face requires BDI to verify purchaser use for each item that it sells. And in fact, under Security Equipment Supply v. Roberts, cited in our briefing as well as in the commissioner's briefing, this court noted in that case that the controlling factor in determining whether a sale qualified as a wholesale sale via being a sale for resale was a determination of what the buyer actually does with the purchased item. And in fact, in the department's own business tax manual, it notes that that taxpayers are expected to know how customers use their products. In this case, as set forth in the record and in the briefing, this produces an impossible burden upon BDI, which has number one, a very high volume of sales. As noted in the briefing and in the record in this case, they have multiple millions, or they have millions of SKUs of different products that are sold with many, many different transactions involved. Number two, they also face the issue of having a lack of data to verify how customers use purchased items. And three, there's also the issue that many of their customers also make purchases of items that they may use for different purposes, some of which would be undisputedly wholesale and some of which would be disputed in this case.
Counsel, excuse me for interrupting. As I understand, the department relies upon certain certificates and exemption forms of customers to make the determination as to that 50% threshold. How does that relate and translate into an impossible burden upon your client?
Yes, Your Honor. Well, the department in this case has prepared, they have advocated for using what we call a workaround. They use a system where they look on a customer by customer basis to make a determination of whether a customer is wholesale or retail. And they, as Your Honor notes, they look to sales and use tax exemption certificates provided by that customer to wholly classify that customer as either retail or wholesale. The problem with that workaround, however, is that it ignores the statutory requirement under 674702 that each sale has to be examined. A requirement also I've noted in the security equipment supply case. It also, under the business tax statutes, they simply do not provide for the use of these certificates. For example, under sales and use tax, which is the certificates that the department relies upon, there is a presumption under sales and use tax law that if a customer provides a seller with an exemption certificate claiming that it's a resale or claiming it's exempt for some other purpose, then it relieves the seller of any liability should that customer not actually use the purchased item for a qualifying exempt purpose. And that does in fact happen. In fact, there's Rule 8 sales under Tennessee law where customers oftentimes they may provide a resale certificate, but yet they'll withdraw certain items from inventory for personal use, which would not qualify for resale. And they have to then later report that to the department. So there's no presumption under business tax statutes that provides that just because they provide a resale certificate, there's a presumption that all of their that they're actually using those products in a manner that would qualify for a wholesale determination. So needless to say, there's just simply not a mechanism under business tax law to provide for the use of such a certificate. Also, as noted in our briefing, the department's wholesale / retail determination on a customer by customer basis beyond being inconsistent with the requirements under 674702, it also ignores the many instances where BDI customers may purchase products for multiple different uses. As if the court looks into the record, and the department's auditor in this case testified, or the audit supervisor testified, that the department only requires that they provide one certificate. Generally they're not going to provide multiple sales and use tax certificates, and they're going to under their system, they want to wholly classify a purchaser as either retail or wholesale, regardless if they in fact actually use make a wholesale use out of all of their purchased items. Once again, the statute actually requires you look at each purchase. How was that item used? And in fact, in this case, I'll note in the record that the department has acknowledged the impossible burden of such an analysis, of such a sale by sale, product by product analysis in this case. And in fact, courts in Tennessee, as well as in multiple other states, or in other states, have recognized that a statute imposing an impossible burden upon a taxpayer, which is being imposed on BDI in this case under the department's position, simply does not survive constitutional muster. And we've cited to those cases in our briefing, including a Tennessee federal court decision in Buck v. Horton. In this case, if the court finds that BDI sales to manufacturers that they're required to actually be incorporated into a product, there are disputed issues of fact that would have to be resolved under the department's theory in this case. Particularly in the record, there's a question of what is the actual percentage of wholesale versus retail sales that would have to be determined with a proper application of the statute, which requires an analysis on a sale by sale basis. And the record in this case does not contain, or there's not been a finding of what that percentage would be. And that fact is in fact, clearly material with regard to the department's position in this case. But that being said, the constitutionality, the impossibility argument, if this court reads and interprets the statute as proposed by BDI in this case and finds that, that the incorporation into a final product requirement does not apply all the way across the board, then that alleviates the as applied constitutional challenge or issue that's been raised in this case, because it would allow for BDI sales to manufacturers to qualify as wholesale, regardless of whether the sales or the items purchased are incorporated into manufacturing machinery, or instead whether those products are incorporated into a final product manufactured for resale. And it's undisputed in this case that those two categories of sales together constitute the majority of the sales made by BDI in this case. So with that being stated, we would request the court to adopt the BDI's construction of the statute and to reverse the lower court and award judgment in BDI's favor. Thank you.
Thank you very much. You have your time for rebuttal for the appellee. Yes, sir. We cannot hear you. You're muted.
All right, I'm sorry. Good morning, may it please the court. My name is John Wyke, and I'm with the Attorney General's office, and I represent David Gerregano, the Commissioner of Revenue. I just want to spend a little bit of time on the statutory language. This is language that is pretty obviously works the way that the Commissioner has construed it and the way that the courts have construed it for many years. The meaning of this language does not change because the context is different between the two different tax laws. I just want to give an example and to show that regardless of the sort of competing canons from Sutherland or other sources on statutory construction, the three items, manufacture, convert, and process, are more or less the same, but not quite. And so it was obvious that what the legislature wanted to do was make sure that all of those were covered. But it's also clear that this is a statute that relates to the sale of raw materials. It's called industrial materials. And the legislature knows how to create an industrial machinery or equipment exemption as it does in the sales tax. It calls that kind of thing industrial machinery or equipment. Just common sense dictates the construction that the commissioner and the courts have put on this statute. I just wanted to give an example. If I said to someone, bring me a knife, a fork, and a spoon from the drawer, and they only brought back a spoon, I would think that something was wrong and that they had really misunderstood. Those things obviously relate to that last modifying section, and it would be ridiculous to have to restate the phrase from the drawer for each one. If I said, bring me the blender, the ice cream, and a spoon from the drawer, then things would be different. But anyway, this is long settled, and it's based on common sense. I need to turn to the impossibility argument. And my theme is going to be that the department is trying very hard to tell this taxpayer, yes, you may think it's impossible, but the good news is it's not necessary here to do the impossible. This case is what it is because of the way it started with BDI's return. On its return, BDI claimed that all of its sales were wholesale. And the auditor, faced with that claim and having done a sales tax audit, knew that that couldn't be correct. She knew that based on the existence of industrial machinery certificates in the record, BDI was making some sales that had to be retail. And the auditor made a statement in the audit report that has been misconstrued and sort of run with. She said, the auditor, referring to herself, the auditor was unable to verify the accuracy of taxpayers' claim of 100% wholesale sales for any branch location or annual filing period in the audit period. The auditor, so what did she do? The auditor calculated the business tax based on 100% retail sales with the corresponding rate applied and assessed additional business tax due based on the difference between the two rates. The auditor is saying BDI claimed that 100% of its sales were wholesale, and so it was entitled to the lower wholesale rate. I know for sure that that can't be the case. BDI has taken that to mean that the auditor somehow assumed that it was necessary to determine what happened to 100% of the items that it sold. But it's really only necessary to determine the nature of 50% of BDI's sales. Perhaps the auditor could have saved herself and all of us some trouble if she had said that, but that's the standard that she applied. The statute didn't change because of the way she used the term, the figure 100%. A customer of a company like BDI, which is a manufacturer, has several ways of purchasing what it purchases from BDI free of sales tax. The two that have come into play here are industrial machinery certificates and resale certificates. If it presents a resale certificate, then that means that it is incorporating the items that it buys from BDI into its finished product, and those qualify as retail sales. If it is presenting an industrial machinery certificate, that creates a presumption that it is using those products as part of its equipment. And so that those are going to be presumed to be retail sales for purposes of the business tax. That's slightly.
Counsel, excuse me for interrupting.
Sure.
With regard to these certificates that you referenced, are those filed by the customers on an annual basis?
I don't know exactly how that works, Your Honor. I think it works with each customer and each purchase. The customer has to have that authorization for the industrial machinery. It has to have that from the department. In both cases, it's representing to BDI something about how it is going to use the what it purchases.
Would those certificates and exemption forms be documents that would be available not only to the department, but also to BDI and similar manufacturers?
They would, and they would have to be presented to BDI before that customer could purchase what it's purchasing from BDI free of sales tax. BDI has to know that it can make that sale without collecting the sales tax, because otherwise it would be on the hook for the sales tax and would then have to either come up with the money on its own. It would owe sales tax, in other words, because it would not have collected or remitted the sales tax. So what happened here is that the auditor worked with the forms that she already knew of and was unable to establish that BDI had over 50% wholesale sales. BDI could have been more helpful in this situation, but instead BDI took the position in the audit and through the informal conference process and on into this case that it's really entitled to claim the wholesale rate for all of its sales to any manufacturer simply because they're manufacturers, based on its misreading of the statute. Once we get past that, then BDI claims that it would be impossible to meet its burden. The department is trying to tell BDI, yes, it would be very difficult. The department's witness, Mr. Robertson, said, yes, it would be impractical. But the good news is you don't have to do it. It's not necessary. And that's the part that BDI is not accepting. All BDI has to do is work towards the 50% level. If it has enough if it has enough resale certificates, then it can treat all of the sales to those customers as wholesale and meet its 50% level. If it has industrial machinery certificates, there's a presumption that that is simply that customer is simply using that equipment, those bearings in its industrial production equipment. And since this is the business tax and not the sales tax, BDI has to pay business tax on those sales at the retail rate. If BDI can show somehow that those customers are actually using some of its purchases for conversion into component parts, it can try to convince the department that that's what it's doing. And under the principles of Edmondson and Wiley Steel, it can reduce it can change the picture. But it's sort of playing passive and skeptical and saying we don't think that we can do that. Frankly, I find that first of all, a misreading of the principles of the business tax and the department's operation, and a little bit hard to square with BDI's business and the facts. First of all, yes, these two rates are based on what the customer actually does with the purchases, but no one has said anything on the department side that would actually require BDI to play private detective and determine what happens to every single ball bearing that it sells to somebody. That's a straw man. These exemption certificates establish that well enough for the sales tax. They should establish it well enough also for the business tax. The fact here may simply be that BDI sells most of what it sells to customers who actually do not convert the product into component parts of finished products, but actually use them in the manufacturing process. That's what BDI's complaint says. And if BDI knows different, who better than a company called Bearing Distributors to determine how bearings are distributed? BDI must have some clue as to how its products are used. Its only business, as far as I know, is selling ball bearings and the casings that they come in. It must know the difference between ones that are used that become, say, component parts of automobiles and those that become parts of the machinery that produce automobiles. It has a leg up. This is yet another case where the department has, the taxpayer has monopoly on the information about its business. And all the department can do is accept what is believable, what's credible from the taxpayer. But this taxpayer is saying, well, we think it would just take too much. And they've cited an ancient case related to song royalties from a time before computers, and really in some ways, no standard that the court can apply as to impossibility. But I'm suggesting, regardless of whether there is such a standard or any sort of impermissible, unconstitutional impossibility under case law, I'm suggesting that it's not impossible and that it's not what BDI is also claiming that it would have to do is simply unnecessary. Mr. Robertson explained in his deposition how he would go about getting to the 50% level if he were BDI. Go customer by customer until you get there. But that assumes that you can actually get there. And the plain fact may be that BDI can't get there. So that's kind of our position. I know that these different terms with the resale certificates and the industrial machinery certificates can be kind of confusing. That confuse me. But it is practical. It is workable for the department to use certificates that are used in the sales tax area here to establish the nature of the sales that BDI is making to its customers for purposes of the business tax. As the trial court said, exactly right, the department is actually being rather generous to BDI. BDI is just simply being skeptical and sort of not taking the good news for an answer. So unless there are any other questions, I have some time left, but don't feel I need to use every second of it. We ask that
any questions.
Yeah, we ask that this court affirm the sound reasoning of the trial court in all respects. Thank you.
Thank you very much, sir. You have your rebuttal? Yes, sir.
Yes, Your Honor. I'd like to touch on a few points raised by General Wyke. Number one, the clear reading of the statute requires that you have to look at each sale. We've cited to the security equipment case, which also affirms this result, as well as the department's own manual. With regard to impossibility, there is simply no statutory authority permitting the department to make retail or wholesale determinations on a customer by customer basis. As noted by General Wyke, they're looking at resales or sales and use tax exemption certificates to classify broadly every sale to a particular customer as either entirely wholesale or entirely retail. That's simply not allowed under the business tax statutory regime. The department, simply put, the department's proposed workaround, while it's a workaround that could work if it were statutorily authorized and permitted, it's simply not statutorily authorized or permitted under business tax law. Another point I'd like to touch on is General Wyke made a statement about sales and use tax exemption certificates and there being a presumption that if a customer provided a resale certificate, that customer is making a wholesale sale. That simply, under business tax law, does not provide any such presumption. There are presumptions that apply under sales and use tax law, which is a different statutory regime, but under business tax, there is no such presumption that applies in that context. They've cited to no statute or rule or a regulation or statute or other statutory authority permitting that. And there's a good reason for it, because it simply does not exist. General Wyke made a comment about BDI not being required to know the customer use of each item purchased, but I will note back to the manual that provisions in their manual available public record online says, that sellers are required to know what their customers, how they are using the products. And in this case, it's not BDI that has a monopoly on this information. It's BDI's customers that have that information, not BDI. There's no statutory requirement or legal requirement for the customers to provide this information to BDI. BDI did, in fact, as set forth in the record, try to obtain information from customers, but the customers largely did not respond. And there's no duty for them to even do so. With regard to General White's statement, with regard to his, he's referring to a series qualifier canon as part of statutory construction. But I will note briefly, as set forth in our briefing, that no court in Tennessee that we have found has adopted that canon. And it would also require that the terms manufacture, convert, or conversion be all deemed as the same. And that goes against statutory construction standards in Tennessee. And my time is up.
Thank you very much. Thanks to both of the attorneys for your presentation. You will receive our opinion on this matter within a reasonable period of time. At this point, if there's nothing further, Madam Clerk, will you recess court until the next call case?
This honorable court is in recess until 2 p.m.